So welcome. My name is Jose Alvarez. I'm the faculty director of the U.S. Asia Law Institute, and today's program is about Singapore's quick rise as an international arbitration center, led by the incomparable Lucy Reed, who I will introduce. But first, I want to make sure people know that next week at about the same time, we're having a talk on outward-bound investment restrictions. That is the latest thing the U.S. is doing, which is restricting its outward-bound investment flows in one particular instance, targeting China in particular. And that will be led by Professor Harlan Cohen, who is a professor of law at Fordham Law School. So that's Tuesday, October 21st, 2:30, 3:30 Eastern Time. Also a hybrid event, as is this one. So before I turn it over to Lucy, who will, as is our custom, talk about 15 or 20 minutes, no more. I will take the mic out of her hands at that point, because we do have, thanks to Franco Ferrari's class, a number of folks here who might actually have questions about arbitration generally. So Lucy Reed is, and I want to make sure I get all the titles right because there are a lot of titles attached to her name, President of the Singapore International Arbitration Center Court, immediate past President of the International Council for Commercial Arbitration, ICCA, and an independent arbitrator with Arbitration Chambers in New York. She specializes in investor state and complex international commercial disputes. And she was recognized as Tier 1 of Chambers and Partners' most in-demand arbitrators global-wide in 2025. Among her many other activities, she has been on the board of the Register of Damages caused by the aggression of the Russian Federation against Ukraine. And before retiring in 2016, she led the Freshfields Global International Arbitration Group and also led as director, the Center for International Law at the National University of Singapore, who is a frequent collaborator in this series. And among other positions, at least relevant to Asia, she was general counsel of the Korean Peninsula Energy Development Organization, and she led in that capacity negotiations with North Korea. She does not mention, but she is a past president of the American Society of International Law. And with that, I'll turn it over to Lucy.
All right. Thank you all for coming. It's a pleasure to talk to this group, those of you on Zoom as well, and thank you, Prof. Ferrari, for having some of your arbitration students here. I have been asked to talk about Singapore, and that's what I will focus on. How many, just by a quick show of hands, how many of you are familiar with the history of Singapore as a nation? A few. Okay. Well, I want to know that because I want to start with a bit of introduction, and that is that Singapore became a country only in 1965 when it separated from Malaysia and under Lee Kuan Yew became a nation. It was when it started extremely poor. And Singapore has basically no natural resources. It doesn't even have its own drinkable water. It's an island state. It's very small. Now there are about 3.5 million citizens in Singapore and another 1 million or 1.5 million actually guest workers, really. So it's everything that I say about how Singapore has managed to do what it does requires you to understand how small it is and how easy it is to talk to members of the government and get certain things done. And I'll show you a few of these slides. This is what the main quay looked like in 1965. You could see there were warehouses and what they called bum boats, cargo boats. And I got some of these slides from the Minister of Law, actually. This is a slide that compares the port in the early days to the port today. Singapore does things like destroying, tearing down its huge port and building one that's 3 times as big on reclaimed territory to be able to have the super tankers come. The housing pictures, I think, are most interesting because people my age and younger who are now ministers grew up in houses like this, in what they call the kampongs in Singapore. A lot of people never even got into the main part of the city. There was no toilets, no nothing, extremely poor. Now this is, and the bottom is what the housing in Singapore looks like now. And then racial harmony, we don't need to talk about today. This, I gave a lecture on this. This is a train station for the beginning of the train that goes from Singapore to Malaysia and down, which was the subject of an extremely fascinating arbitration, which I won't go into, but it led to trading of properties between the governments of Malaysia and Singapore. And this building is what, it didn't replace the train station, but it was the equivalent of what Malaysia got a half share in as a result of giving up its train station. So you can see by the pictures what a jump there has been. Now, starting in 1990, Singapore government saw benefits in being a regional center of legal services and commercial dispute resolution. It's absolutely critical for Singapore to have developed into this arbitration center it is today that there was strong government support financially and in every way. Thank you, Jose. Today, I think it's not an exaggeration to say that Singapore is second only to The Hague as a city that is dedicated to international law. And in Singapore, we talk about dispute resolution, international dispute resolution as an industry, because as I said, there aren't natural resources, so it's brain power. So that the motivation was to be what it's become. How was that implemented? There are several pieces to this jigsaw puzzle. The first is legislation. Absolutely critical is legislation. The International Arbitration Act in Singapore is based on the UNCITRAL model law. There's a lot of innovation. So for example, when the Singapore International Arbitration Center started to do emergency arbitrations, it was a pioneer in that field, and interim measures rulings, the legislature almost immediately made emergency arbitration awards and interim measures awards enforceable in Singapore. When Singapore, after seemingly endless discussions, allowed third-party funding in international arbitration cases, although it doesn't allow it in litigation, it's still considered champerty, right away there was legislation allowing that. Interestingly, I just found out this morning, Franco, a case is going up to the Singapore courts based on an award from the Singapore International Arbitration Center, which the tribunal refused to award the costs of third-party funding to the successful claimant on grounds it violates the law and public policy in Singapore, which is going to be an interesting thing to watch. There's also thanks to the judges in Singapore, we have a whole new arbitration protocol for insolvency proceedings, which allow insolvency judges not to turn an insolvency case over to arbitration, but pieces of insolvency cases that are cross-border that can be more quickly resolved by arbitration. Legislation is absolutely critical, and model law is critical. Equally critical is the role of the courts. The Singapore courts are excellent. They are not corrupt. They have a reputation for integrity, for due process, and following the rule of law. They have an experienced bench. In fact, the current Chief Justice, Sundaresh Menon, was an arbitration lawyer when he was in private practice. And they have now something called the Singapore International Commercial Court, which is dealing with all sorts of commercial cases, but all the international arbitration docket goes to the judges on the Singapore International Commercial Court, which includes some retired English judges and some full-time arbitrators. So they're very experienced. And I would say the courts are pro-arbitration for sure. They rarely interfere with arbitration, but they do interfere, and they do occasionally set aside awards. And that's important because a court should not be rubber stamping every international arbitration award that is made. So if anyone asks you to remember two things from my talk today, it's the importance of the law in the courts. I am asked very often by people from ASEAN states especially, what could we do to have an arbitration center the way Singapore is an arbitration center, and I say, you never will because your courts are corrupt, and everybody knows it. And so why would anyone use that as a place to get an arbitration award? Or your courts are too slow, as in the case in India, although India is trying to do better. And I should have also mentioned that once I had to do an interview of the Minister of Law at a big conference, and he stood up and said to the entire audience, look, I'm the Minister of Law. If you want an amendment to our arbitration law, just call me. We can do it. You know, that's how it works here. Depends on the amendment, of course. Okay, also important for Singapore was infrastructure. People forget that Singapore, the Singapore government funded it, built the first integrated arbitration center in the world. That's Maxwell Chambers, where there are hearing rooms, rooms for chambers, offices, and then they expanded into the building next door called Maxwell Suites, so that law firms and practices can be right in the center of arbitration. There's restaurants. It just makes it very easy to have a hearing. Connectivity, very important. Changi is a big airport. You can get there from anywhere. Hospitality, there are good hotels. And in Singapore, more than anywhere, good food. They'll talk about food all the time. This is also important. Incentives. The Singapore government decided to welcome foreign firms practicing international arbitration, make it easy for them to open offices to do that, not litigation in the Singapore courts, but arbitration. Visa-free. Visa-free. I can't tell you how hard it is to get visas to come to do an arbitration in the United States right now from many countries and other countries.
But it's only $100,000, right?
Well, that's for an H-1B, but that was important, that you can parachute in, do a case, parachute out, you don't need a visa. And there was no income taxation on arbitrators, unlike in India, and no withholding, subject to tax, bilateral tax treaties. There were also external factors. The economic rise of China, India, and ASEAN was very important, and that was, and that's why it continues to be important. This is a slide, again, I nicked it from the Minister of Law to show you what's happening in ASEAN, how young it is, the size of the economy. So to have a center in Singapore to do arbitrations for commercial disputes on your own time zone, basically, or near your own time zone, compared to London or Paris or New York, is quite a benefit. I should have said at the beginning, by the way, that Singapore is now ranked with London and Paris and ahead of New York as an arbitration center for the reasons that I'm going through, and that's in just 30 years, which is no other country has achieved that. And my premise is they won't, because they don't have the same things going for them that Singapore did. Also, Singapore is the top Asian country in the Corruption Perception Index and the Rule of Law Index. Next factor, long-term vision and commitment. The government put a lot of money, a lot of talent and brain power into developing Singapore as an arbitration center. They built the ecosystem, and I don't like the word ecosystem. People use it a lot in arbitration, but it's important to know that in Singapore, with government support, there's also the Singapore International Mediation Center. There's also the Singapore Institute of Arbitration. There's now an accredited LLM class with a full international arbitration professor at National University of Singapore. There are many, there's Maxwell dialogues. There's many things going on with arbitration and mediation in Singapore right now. And of course, a Singaporean led the UN negotiations for the Singapore Convention on Enforcement of Mediation Awards. We at the Singapore International Arbitration Center, with government support, do a lot of training and education, especially in China, India, and ASEAN, and now the Gulf, and in US. But I want to stop right here and say something that is extremely important. And some people have been making misstatements about this recently. Never, ever, ever has the government interfered with the independence of the Singapore International Arbitration Center Court. They have no say, no input, no inquiries, no reports, no nothing from us on how the cases are being managed. And SIAC tribunals have issued decisions. In fact, one came out just recently against Tata, the Indian company, that are diplomatically difficult for the government of Singapore, but it is completely hands-off. Independence is important. Many arbitration institutions in other countries that have not succeeded cannot separate themselves from the government on substance. They take money, they feel that they have to bend to the government's interest in cases, for example. Next factor, and this is also important, SIAC, Singapore International Arbitration Center Court, and our board are truly international. The local staff, the administrative staff, are mostly Singaporeans for obvious reasons, but I can't remember what year it was, but SIAC took the brave step several years ago to make a non-Singaporean the president of the court. It was Michael Pryles, followed by Gary Bourne, followed by me. The registrar, Vivek Neelakantan, is an ethnic Indian Singaporean. There's now an Australian deputy registrar and a Malaysian deputy registrar. And the approximately 15 lawyers who work in the secretariat doing the actual case management come from 13 different countries. So a lot of languages, a lot of civil and common law background. Other institutions have been very protectionist and tried to keep out non-nationals from the infrastructure. And that reminds me to say that there was quite a battle when Singapore opened up the practice of international arbitration from the local firms who wanted to be protected. They wanted to be given a monopoly on doing the arbitration cases in Singapore, and the government said, basically the government said, nuts to you. We're going to allow foreigners in, and that will improve you. And that's what's happened. The local firms have developed very strong arbitration practices. Right now, in places in the Gulf, I see there's a lot of nationalism trying to start up new institutions with only a local role. And it doesn't work because if you're advising a multinational company, you want an international institution to deal with. So another element of that is Singapore welcomed the ICC, the American Arbitration Association, the PCA, all sorts of other arbitration institutions have offices right near us in Maxwell Chambers and Maxwell Suites. We all know each other. ICCID has now opened its first overseas office in Singapore, which says a lot. I think I'll just say a few words, Jose, about SIAC because that's more detailed. We started, let's see if I need any slides. That's the railroad station. This was just the importance of rule of law. These are the institutions that have been welcomed. This is what Maxwell Suites looks like. By the way, Maxwell Suites used to be the residence hall for the traffic policemen in Singapore. And when you go there, I've had a lot of people say, was this a jail? No, it wasn't a jail, but it was a dormitory where families lived in 2 rooms. And across the street, there's a parking lot where people took their driving tests. But they recycle buildings a lot in Singapore. So yes, I do want to stop here. Take a look at this slide. It shows you, and this is from 2 years ago at least, from the Queen Mary White & Case International Arbitration Survey, that in a sense, miraculously, in just 35 years, Singapore has jumped up to be ranked with London and Paris as a globally preferred seat for arbitration, and SIAC is, tied with ICC, LCIA. But all these places are good. I never speak badly about any of the other institutions or venues. There's a reason to have an important choice in international arbitration. So SIAC, when it was started in 1991, it had 2 cases. 2. And yet the government did support it. Oh no, now I have to look at myself. Now we get 600 or 700 new cases a year. We just hit 550. For this year, there are about 1,300 under active management right now. Important fact, 90% are truly international, truly cross-border parties. 2024, parties came from 72 jurisdictions. Top users are India, China, and the US. And our governance structure at SIAC is, I'll do it quickly, we have a board of 5 or 6 people who decide policy and budget, things like that. I'm on the board. I'm the only person on the board and the court. I'm president of the court. The 2 vice presidents are names known to some of you, Toby Landau, KC, of course, and Kavinder Bull, who's one of the leading senior counsel in Singapore. And then we have 40 court members, a bit fewer than 40 court members from 25 countries who are there to advise on rule amendments, which we just did, a 7th edition of the rules for 2025 to keep them current. They decide challenges to arbitrators in committees. But this is very different from ICC. I was also a vice president on the ICC court. Under our rules, as the president, I actually do things every day. I personally appoint arbitrators when the parties have not been able to do so. It's usually sole arbitrators or chairs on tribunals. I personally decide whether a case is suitable for emergency treatment. I personally decide if something should be expedited. I personally can decide consolidation, things like that. It's not a power I like. It's a responsibility. And of course, I never do any of those things, it's usually on email in the morning, if I haven't cleared conflicts first for all the parties. So it's a very active role for me. Last thing I think I'll mention is, like the ICC, and this is also very important at the institution level, SIAC scrutinizes the draft awards that the arbitrators put in. At the ICC court, the final scrutiny is done by a committee of 3 court members who are volunteer experts in international arbitration who do it pro bono. So it's kind of divided, but at SIAC, the registrar with the counsel, does the scrutiny of the award and has back and forth. They find math mistakes, they find other mistakes. The idea is to make sure the quality of the award is as good as possible. And for that reason, it's very rare for an SIAC award to be set aside in Singapore or any country. It does happen. Interesting, I'll end with an interesting case recently, which will show you the independence between the institution, the arbitrators, and the court. There was a case to set aside an SIAC award for violation of natural justice, or public law, they would say, because the arbitrators decided an important point on an issue that neither party had briefed. Now, I know I'm online, but I still think I can say this. That was pointed out to the arbitrators in scrutiny, but they did not change that part of their award, and that award was remanded by the Singapore International Commercial Court for them to revisit the issue. That tribunal said they would not revisit the issue, which is not surprising. It's a bit difficult. And just this week, the Supreme Court, in Singapore said it was a mistake for the lower instance court to allow a remand, and they should have set aside the whole award. That natural justice is too important to be cutting and pasting, and particularly when you don't expect a tribunal to feel comfortable about saying, whoops, we violated natural justice, now we'll change it. So that's a quick run through. I want you to remember how that the Singapore International Arbitration Center, which does the cases, is supported by the government. In fact, government money pays for our external academies, where we go to China and India and elsewhere teaching and doing a lot of conferences. But in terms of running the cases and the substantive work, we're completely independent and paid for by the parties. Enough?
Enough. So I know there's bound to be considerable questions in the room, but I want to just sort of start us off, because you mentioned that Singapore was convinced that this was an important thing to do, and it considers it important enough to devote some funds, obviously, to this. And I'm just, if you want to say a few more words about how it or other countries see arbitration playing out to a country's benefit. Exactly, is it an sheer economic benefit? Is it a political benefit? Are there rule of law externalities? That is, that it positively affects national law or national judges? Is it just purely reputational? Exactly what is the benefit, or what are the benefits as seen by Singapore's government?
I think it's safe to say that Singapore is a special case where, as a small nation state without natural resources, it's always looking for ways to do what it's done, which has become one of the leading economies in the world using what they have access to. And one thing they have access to is brain power. And thanks to Lee Kuan Yew, you can say a lot about Lee Kuan Yew, but it's a non-corrupt country, and they're very quick to punish any sense of corruption. So the courts developed to be very fair early on, and the government, the ministers all have their own constituencies, actually. They have their own jurisdictions where they know the people. So for Singapore, it was, I wouldn't say it's survival by any means, but it was one of the few areas that they could build on using what they have. And I remember, so many years ago, before that, Singapore really decided to go whole hog with Maxwell Chambers and investing in more of an infrastructure. They sent people around the world to talk to leading arbitration specialists to say, do you think it will be used? What can we do to make it popular with users? And that led to the structure I told you about, visa-free, tax-free, taking advantage of the buildings, old buildings that the government turned over. Having said that, no doubt about it, it helps the local economy. People come in and they use the airlines and they use the hotels and they bring their spouses and they shop and they eat a lot because Singapore food is more important than anything in many ways. But that wouldn't have worked if the Singapore government didn't say, you've got 25 or 30 years to really make a go of it. And I've personally seen I've been asked for advice by lots of cities and countries saying, what can we do to be a successful arbitration center? Because they think they'll make a lot of money, I guess, and attract their local bar and their local businesses and be used. And then I think in Latin America one year they counted 145 regional international arbitration centers, none of which have any cases. Why? All the reasons that I went through. And I should have mentioned one more thing, Jose, which is you would never advise a client to agree in an arbitration clause to take arbitration to a center that's new, that has no track record, because your dispute might not arise for 5 years, 10 years, and then it might not be in existence, which is why the ICC is so important, LCIA is so important, Stockholm is important, Vienna is important, New York is important, and Singapore got itself to be important by having long-term commitment from the government. I think some governments see it as a sign of prestige. You know, it would be nice if we could be Geneva or we could be Vienna and we could be a big, boy or girl in international law. And I'd be curious to see what Prof. Ferrari thinks about that. But it's very hard to achieve.
So let's talk about not achieving it, or what happens when or how do you lose it? So some people, perhaps unfairly, say at one point Hong Kong was seen as the place in Asia, and it seems to be the case that Hong Kong has been displaced, at least to some extent, by Singapore. So we can all speculate as to what happened, but are there lessons from Hong Kong about how you could lose your spot?
The Hong Kong International Arbitration Center is an excellent arbitration center. It has excellent leadership. It has excellent case management. In fact, I was on the board at one time when I lived in Hong Kong. I have nothing negative to say about the institution. However, because of the mainland, the People's Republic, playing a much bigger role in the courts in Hong Kong, leading to some of the core Chinese judges to resign. In protest, there are now many parties who have doubts about whether, if they got an award on Hong Kong soil, that they could count on the courts enforcing it, for example, against a Chinese party. So we in Singapore and other institutions are seeing more arbitration clauses that put Singapore in or Paris in than Hong Kong. It won't go away. Hong Kong is still a very important venue for North Asia disputes and Chinese disputes. But now poor Hong Kong also has to compete with Beijing and Shanghai and Shenzhen, all of which have their own arbitration centers, all of which are getting a lot of money and a lot of support. They will have difficulty getting cases that are not in Chinese language. It will be a language impediment to their developing the way Singapore and English could develop. To think about your question, I have seen when a really bad decision is made by a local court that shows perhaps there's been favoritism or even occasionally bribery, that will destroy the reputation.
Just one case.
If it's a big enough case and it's controversial enough, it will lead the general counsels in multinational companies to say, we are not going there again.
So there's one question that's come up, and it's related to this, so that's why I'm bringing it up, because it was in some of the questions we got in advance. And that is, you've mentioned China. China's made great strides in also changing its own laws to favor arbitration, and it's got quite a stake in this, its own Chinese arbitration mechanisms. Other than language, what constrains China in this field?
I'm not an expert. There might be people in the audience who are. I think there are, language is very important, and lack of familiarity with the Chinese courts is going to lead, say if you've got a company in Australia and a company in Canada, they might be willing to go to Singapore because it's English speaking, it's well known, it has a reputation. For them to agree to go to Beijing or Shanghai just wouldn't make much sense. Korea is very competitive in arbitration. Unfortunately, they've fallen on some hard times in arbitration, but Korean parties and other North Asian parties will increasingly use Chinese institutions. SIAC has like 1 trillion arbitrations, I think. It's literally hundreds of thousands of arbitrations. But as with Singapore, the governments in Beijing and Shanghai in particular are investing a lot of money in new centers that are stunning. They're opulent. The hearing rooms are better than any I've seen anywhere in the world. They're copying Maxwell Chambers now looks a little bit like that house I showed you on the slide compared to what China is doing to attract parties. So, and they're training students. I think foreign students, I taught a lot of Chinese students and Indian students when I was at National University of Singapore. They have a lot of scholarships and they're focusing, one field is international arbitration, and they're multilingual. So I think you have to watch China. India has a new center as well. I think India is going to have a tough time because of the delays in the court system. Yeah.
Right. So I'll open it up because there's far more students and others here than we normally have before. I have tons of things I could ask you, but I'll open it up to folks here. So raise your hands, and then we'll also have folks in the chat. Don't be shy. And if you are, I'll just jump in.
Yeah, don't be shy. Why would you? Oh,
yes.
Hi. I'm Maggie. I'm a geologist here. And I used to work in Singapore, so I completely agree with your ideas about Singapore and food being the best. I have a question about sort of changes. Obviously, as you mentioned, Singapore within a period of 30 years has managed to make itself into an arbitration center, but a lot of that involves sort of making quick changes into the arbitration rules and constantly adapting to, as you mentioned, the Minister of Law, what he said, what parties are interested in. And so I was curious, alongside other factors that lead to the choice of arbitration institution, one of them is like sort of certainty and like consistency over time. And I was wondering if you think that sort of with these changes to the rules, if that's a matter of if there will be concerns by parties about, you know, the potential impacts of that for consistency in future.
So maybe you want to, because it was no mic.
Summarize the question.
Yeah.
In just the question was, don't changes in the rules for an arbitration center essentially lead to some fear of inconsistency, and that would deter people from putting the center in an arbitration clause? And the answer is absolutely yes, that is true. And that's one of the reasons that arbitration rules are changed infrequently. So the new SIAC rules from 2025 are the first new set since 2016. And we felt we had to change the rules to keep up with things like third-party funding. And we also added a whole new procedure, which is called the streamlined procedure. You change your rules because of demand from the users, not because you feel like it. And SIC arbitration is too expensive for small cases. It's like ICC, it's pro rata, depending on the size of the dispute. So now we always had expedited arbitration for cases originally under 6 million Singapore dollars was an option. We've raised that to 10 million Singapore dollars. Expedited means it should be done in 6 months, basically, with one arbitrator only. Streamlined is for cases that are 1 million Singapore dollars or under. And the default is the case will be only on the papers. The no witnesses, no hearing. It's a default. The parties and the arbitrator could do that if they want to. A summary award, so it doesn't have to be a full-fledged, excessively long, as too many awards are. But most important, the fees cannot be more than 50% of the fees otherwise set for SIC arbitrations. And there's you can apply to have your small case not heard under the streamlined procedure. And we've had several streamlined cases start in 2025 with great happiness by the local users. And we've had several applications that did not apply because they're too complicated to even dream of being done in 3 months. So that's one of the things I have to decide. But you don't want to keep changing your rules. And it took us 3 years of discussions at all levels to come up with the 2025 rules. And controversially, very controversially, there's now a possibility to get an ex parte emergency decision called a preliminary protective order from an emergency arbitrator by one party without notifying the other side. Unsatral talked about this forever. But that is only for the cases where you know if the other side hears what you're doing, they'll do it. So if they know you want to stop the ship in the port or gets a bank account frozen, if you tell them they're going to do it overnight. And that order only stays in existence 24 hours before the other side hears about it. And then it becomes a normal emergency arbitration. This is interesting for the arbitration students. I think at SIC, I just saw we've done 170 emergency arbitrations applications over the years. Only one application has been denied. Not for emergency relief, but to allow the case to be done on the emergency schedule, which is basically 2 weeks from start to finish. And that I decide whether a case or Toby or Kavinder would, if I can't do it, can go to the emergency process. And the reason we said no is the counsel in the application said something was going to happen 6 months hence. That's hardly an emergency. So we had to say, no, we're not going to go. But often, for some reason, it's usually Friday nights, US time, that the applications come in. And I'm always watching because we normally can, when I get something called a case briefing form from one of the counsel in SIAC, telling me, here's what's happened, here's the emergency application, they paid their fee, and here are the names of 5 potential emergency arbitrators who have cleared conflicts or are in the process of clearing conflicts. So I can, sometimes, in 5 minutes, I read the note and I appoint an emergency arbitrator, and the parties within 2 hours get started. That's the benefit of focused decision-making by the president, which the ICC doesn't really have the benefit of.
So what you've just said also suggests an old criticism, and I'm curious what your reaction, especially in an investor state. It is said that small investors are disadvantaged. They don't go to arbitration. But you've just described a bunch of rules that are trying to attract the smaller claims, which I assume might be smaller. How equal has arbitration become, either on commercial side or on investor state?
I think it's still much more expensive and inaccessible to the small and medium-sized companies. Not so much because of the fees of the institution, but the lawyers. To get an experienced lawyer and be able to pay for an experienced lawyer when a small amount is at issue, even if it's a very tough or simple dispute, it is hard.
So somebody said, and I'm not sure if it's accurate, that the average cost, or maybe it's the median cost of an investor state claim might be 10 million?
Oh, I wouldn't be surprised. When we at Freshfields were really pioneers in the field of BIT arbitrations, and then we used to say
Bilateral investment
treaty, it'll cost you $1 million, and that seemed a lot. Now, that's the salary for first-year associate on Wall Street. So, no, I'm only kidding.
I hope so. I'm clearly in the wrong profession.
I'm only kidding.
I can't help but ask, because you've mentioned the role of training in all of this. And you've trained a lot of folks in arbitration. So I'm curious what you think is the most important things you convey to your arbitration students, whether what it takes to be an excellent litigant, what it takes to be an excellent arbitrator. What's the skill that is the most important thing to take away from Franco's course that he doesn't actually teach?
How many people here are in an international arbitration class? Oh my gosh. Okay. And anyone on Zoom, welcome. I talk about this a lot and at length, so I'll try to just do some bullet points. The first is international arbitration, although it's grown, remains a small field of practice. And
there's no human right to that job.
No.
Oh, that's a surprise to a lot of folks here.
It's still a small practice, and courtesy of professors like Professor Ferrari and my colleagues, it's deemed very attractive practice area, but you have to be realistic. It's still remain a relatively small practice area. It's a procedural specialty. It's not a substantive specialty. So litigation skills are what matter in international arbitration for counsel. I'm almost alone in saying this as far as I can tell. I think there's too much emphasis on oral advocacy and cross-examination in training, because it's very rare that a case will turn on the outcome of a cross-examination. The most important skill, I'll come back to cross in a minute, the most important skill is written advocacy. Absolutely the most important skill, because to be persuasive but fair is important. And I can tell you, I just spent $100 over at FedEx this morning myself to print out a written memorial for a case that I'm chairing a hearing on next week, because I want to be able to read it and mark it up and think about the points that are made in the written advocacy. And I'll carry that with me on the plane, and I'll have it in my hotel room, and I'll go back to it when I'm writing the award. The cross-examination, I will have completely forgotten, unless someone starts crying, which happens sometimes. But I want to say, here's why cross-examination is so important in international arbitration. It's not because you're going to trick a witness into saying, oh, I made it all up, or whatever. It's you cannot get the attention of a CEO or an engineer or a fact witness to sit down with you and think about what really happened, read his or her files, try to remember accurately, the relevant facts. If you can't say, you know, what you sign, you're going to be questioned about under oath or affirmation. So you better not. I don't think people lie. I see very little lying. Well, I see more than my fair share of lying, but I think people just are busy. So the CEO doesn't want to remember exactly what happened or read an old file and know the threat of cross is more important than the cross. I do think moots are, for oral argument are really important. I think the vis is a wonderful competition written and oral. But what I used to say, and my last point is this, what I used to say to my students, even if you don't get a job at the end of the day in international arbitration, at least early on, everything you learn in dispute resolution techniques will help you, whatever your legal practice is, whoever you marry, whatever comes up at the breakfast table. It's very important to have those skills of listening and persuasion.
So what makes for a good arbitrator? You're one of the top. So what makes you successful?
Preparation, active listening. For me, I don't intervene a lot during a hearing the way some people do. If I really need to know something, I will. The most important trait, though, is fairness. There's no doubt about it. It's fairness, is having an open mind when you read the witness statements, hear what the witness have to say, think about the law, and then you do the knitting. And that's what's fun about the practice, is when you knit the facts as you find them to be relevant and material to the applicable law, that's when writing the award gets fun. You also have to have a very hard heart to be a good arbitrator. What do I mean by that? I can't tell you how often the party that loses in my arbitrations, I wish they were winning, because I like, there's equity. I like the counsel. I like the way they've managed themselves. It seems fairer, but if the contract says this, you have to stick to the contract. You just cannot let, your emotions affect it. And a lot of my cases, Jose, because like Professor Ferrari, I'm fortunate to be at the top of the field. Both sides are right. There's absolutely no doubt that both sides are right on the facts and the law. And that's why they're in arbitration, because they couldn't settle, because there's a genuine disagreement. And like Jose, I'm in the field. I started in the field because of the Iranian Revolution. In my law firm, where I was a federal court litigator, ended up with 40 cases before the brand new Iran-U.S. Claims Tribunal, which is the precursor to bilateral investment treaty cases. So it was coincidental.
So one issue that comes
maybe
up.
some of them have questions.
Well, then nobody raised it, so I'm jumping in,
No,
please.
Thank you, first of all. So you talked about elements that made Singapore one of the most chosen seats nowadays. But we can say also that these elements in general can quantify the arbitration friendliness of a jurisdiction. And also you said that Singapore is now reaching Paris and London, which are still top seats. But do you think that Paris and London nowadays meet the requirements you were referring to, or they're just chosen because they have a reputation and still are famous seats?
I would answer your question by saying back to you what you just said without the word just. They will continue, ICCA and LCIA will continue to be very important because they've been doing this for decades and have a reputation for disciplined and fair tribunals issuing awards that are scrutinized formally or informally that do not often get set aside. And if you're a new lawyer and your senior partner says, oh, we have to put an arbitration clause in this $1 billion contract, the options are, here's 5 potential arbitration institutions. The first thing you're going to do is look at the record of awards, whether they're set aside or not in the relevant jurisdictions. So Paris is not going anywhere. ICC is not going anywhere. LCIA is not going anywhere. They have their they have their strengths for sure. Stockholm used to be very important when there were a lot of Soviet disputes before the end of the Cold War. They still have a good caseload. And we have at SIAC investor state rules. They've never been used once. And I'm supposed to say, I hope they will be, because we could administer an investor state case very well. And I'm sure that's true. But if I were advising parties, well, first you have to get in a treaty like ICCID or UNCITRAL generally. I would say ICCID is excellent. Permanent Court of Arbitration is excellent. So why try someone new? I did a case, an investor state case recently administered by a commercial arbitration center. And I didn't think it fit very well. For example, the 2 arbitrators were challenged, and it took a very long time to get those challenges done based on the commercial type rules. So I thought you were going to ask, will other centers emerge? There's not a leading center in the Gulf right now. Saudi is looking at it. Bahrain has a center. Abu Dhabi has a center they're investing a lot of money in. So, and there's Corsica in Egypt, but there's not a center in Africa yet. There may well be room for that development. And Russian cases are a big headache in all the institutions right now because of the sanctions. Very difficult with the Russian cases. Yes.
Yeah. And there's also online, so let's go for a couple more here and then we'll go on.
Thank you very much for coming. You mentioned some of the Gulf states. I'm actually from Bahrain, so I'm curious what your thoughts are on Bahrain arbitration cases now being reviewable in Singapore, and how, because you talked about the reputation of certain Gulf states and it lacking the kind of credibility and impartiality of the Singapore arbitration system. So do you see this as a kind of piggybacking on the reputation and credibility of the Singapore system to advance Bahrain, and perhaps other Gulf states can do this to advance their own arbitration centers?
Thank you for the question. For those of you who don't know, it's the innovation is, I find, very interesting. It's a first. Correct me if I don't get it right, that the Singapore International Commercial Court will be the court for an application to set aside decision by the Bahrain Center. I wasn't in the room where it happened with Jan Paulsen, my former partner, and Chief Justice Menon, but I think it was to support Bahrain, to be, belts and suspenders, to get the Bahrain Center to be used and to take advantage of Singapore's skills at the Singapore International Commercial Court and reputation. I don't think there have been any cases testing it yet. I don't think it will be copied, but yeah, I spent a lot of time in Bahrain. I think it's interesting.
There was one over here, yes.
Yeah, I was just curious, what's the relationship between the SICC and the SIAC? Was the SICC created to support the SIAC? And also, it's been said that SIAC combines the best of arbitration and litigation. For example, it allows appeals, but I'm not really sure how does it fit together.
Okay. SIAC is the Singapore International Arbitration Center. SICC is the Singapore International Commercial Court. They're entirely separate entities. The Singapore International Commercial Court is an incentive of Chief Justice Sundaresh Menon to internationalize commercial litigation in Singapore. It's at the time, the idea of having an international commercial court, and it's the first one, was floated. There was a lot of discussion about would it take work away from the Singapore International Arbitration Center, because parties, if they knew they had a good commercial court for a cross-border dispute, wouldn't they prefer to go to somewhere where they have an appeal, a right of appeal if there's a bad decision? Some people thought it would, some people thought it wouldn't. In fact, it hasn't affected the caseload of the Singapore International Arbitration Center at all. And the SICC has its own caseload, and it is a national court. a lot of people think it's like an arbitration center. It's not. It is part of the Singapore National Court, and I can't remember if it's half or more of the judges on the Singapore International Commercial Court are also High Court judges and Supreme Court judges in Singapore. When I was counsel, I often said to our clients, don't go to arbitration if you can avoid it. I mean, it's really important to have a right of appeal for a bad decision, and the public and the transparency of it and the expert judges. Arbitration can be risky depending on things. But the SICC has fulfilled that role now, and it's being copied. There are a lot of commercial courts now coming up, but they're entirely separate.
So we do have some online.
Couple quick online questions. The first one, has AI made arbitration cases any easier or affected arbitration in any way? And the other is from someone who is currently based in Singapore pursuing a specialized LLM program that you mentioned, the International Arbitration at National University of Singapore. And he asks, from your perspective, what are the key opportunities and emerging threats that Singapore should anticipate to sustain its position as the leading arbitration seat?
Oh, easy questions. AI, I am not as immersed in it as other people. We're exploring using AI for certain administrative functions in the Singapore International Arbitration Center. I think it's inevitable that everybody will, in order to cut down on not wasted time, but not time that's not necessarily spent by humans. But in the practice, as you've all heard of the cases in New York and elsewhere, where AI makes up, hallucinates cases that don't exist. So I think we're in an age right now where we're watching regulation, including the disclosure that should be given about whether you used AI for research, whether you used AI for drafting. Some people think we should, some people think we shouldn't. But it's colleagues really like the law-focused AI programs like Harvey. They say if you feed in, 4 applications for interim measures and say, here are the facts in this case, could you do a first draft? They say it's miraculous, but always has to be reviewed independently, of course. Document discovery, in my life, it went, to electronic. When I was a young lawyer, I used to go through hard copy files with Post-it notes for months on end looking at documents. This will be the next revolution, thank goodness. But confidentiality is very important. The law firms have their own systems now. They're all developing their own internal systems. No one dares put confidential arbitration documents out on the web or chat GPT. Singapore, threats, I think Singapore's good at welcoming competition. That's why all the competitor institutions are welcome to have their offices in Maxwell Chambers, and foreign lawyers are invited to come. They think it lifts everyone's game. I think we don't know enough about AI and how that will affect the practice of law in general.
So I think we're out, but you can stay a few minutes after for
Okay, sure.
a few questions, but let us thank you.
You're welcome.